Identity theft. What is it? How does Texas punish identity theft? What can you do about it if you're innocent? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk to you about the broad umbrella term of identity theft. Many people talk about identity theft. They have no idea what they're talking about. They don't know what the actual crimes are. They don't know what Texas law has to say about it. I want to break that down for you here today. And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, now under Texas law, listen, there's different types of identity theft. The federal government can sometimes pursue federal charges against someone for identity theft, but I'm going to talk to you about state charges, Texas law specifically today. And under Texas law, it's usually broken down into two main components. And there's another one, but the two big ones are credit debit card abuse or fraudulent use of possession of identifying information. Now, I'm not going to spend a lot of time talking about credit or debit card abuse. I actually have done a different video on this, so I encourage you to go back into my YouTube channel, do a search for credit debit card abuse. You'll find that there, and I cover this in a more exhaustive way. But just to let you know, we know what that is, right? Credit or debit card abuse is essentially taking someone else's credit or debit card or using the information from their credit or debit card, using it to process and essentially commit a fraud against another person. Now, the interesting thing about it is it doesn't matter what the value is. You could use it, someone could use that amount to steal a packet of bubble gum for $1.50, and using the credit card information is actually by itself sufficient to constitute a state jail felony offense, punishable by up to 2 years in prison and up to a $10,000 fine. Okay, now let's talk more about the one charge that I haven't done a video on yet, and that is fraudulent use or possession of identifying information. You'll want to go to under Texas Penal Code, section 32.51, the crime of fraudulent use or possession of identifying information, aka identity theft under Texas law, requires you commit this crime if, with the intent to harm or defraud another, one obtains, possesses, transfers, or uses an item of number one, identifying information of another person without their consent, number two, information concerning a deceased natural person that would be identifying information of that person were they alive, if the item of information is obtained, possessed, transferred, or used without that legal authorization. So you're taking a deceased person's information and you're using it for your benefit. Or number three, identifying information of a child younger than 18 years of age. And when determining what qualifies as identifying information, this is always a question that's brought up. What is identifying information? Texas law states that any information that identifies a person is sufficient. So examples of that would include Social Security cards, financial account numbers, financial information, government-issued identification numbers. So whether it's a license, a Social Security, all of that, that's personal, that's identifying information. So the next question that people ask is, you mentioned the word consent. How does someone know if they have consent as defined under Texas law? Well, consent is defined under Texas Penal Code, section 1.07A11. And it says it must be express or apparent. The law speaks about assent in fact, which means there must be an actual or real agreement, like a contract, an actual agreement between the parties. There, assuming you have consent is not just going to meet the definition. So don't just say, I know this person, I'm sure they would be okay with it. You cannot make assumptions. If you make assumptions about consent, you don't have consent. It must be expressed. It must be very clear that there was consent, okay? Now, what qualifies as identifying information under Texas Penal Code 32.51? I want to unpack this a little bit more. The state of Texas must prove beyond a reasonable doubt that the information alleged to have been possessed or used did in fact identify the individual. And what are some things that have to be listed on there? Now, I'm giving you even more detail on this term, identifying information. Number one, including their name, date of birth, unique data specific to that individual. So if there's information like a fingerprint, voice authorization, retina or iris image, unique electronic identification numbers, addresses, routing numbers, financial account information, telecommunication identifying information or device, social security numbers or government identification numbers. Now I know I'm bogging you down with a lot of just specific legal jargon, but I think it's important that you understand the law is specific about what identity theft actually is, okay? It must be identifying information. Now, how does the state of Texas prove criminal intent to harm or defraud? So one is an example where you just possess it. And we're going to break down the legal ramifications for punishment on this, and there is a distinction between the two. One situation is you're just possessing that information. The other situation is you're using it with the intent to harm or defraud another. Under Texas Penal Code section 32.521, there is a presumption of an intent to harm or defraud another person if another person, here it is, possesses one, the identifying information of 3 or more people. So what do we mean by that? What if somebody's in their purse or in their pocket, they've got 3 different IDs, 3 different social security card numbers, 3 different bank card information? There's a presumption it's being used to harm or defraud. That's what it's saying. Number 2, identifying information of 3 or more deceased persons. Same situation. Number 3, or identifying information of 3 or more persons or deceased persons, okay? So a combination of all of that. If you've got 3 or more of these things in your pocket or in your purse, they're allowed to actually presume that there's a presumption of intent to harm or defraud. So it only applies to individuals that are in possession of these items, not businesses that engage in business activity. Okay, just want to make that distinction. So what are the penalties for identity theft in Texas? If the number of items obtained, possessed, transferred, or used is less than 5, so let's look at it first. 5 or less items, you're now talking about a state jail felony, punishable by up to 2 years in prison and up to a $10,000 fine. If the number of items is 5 items or more, but less than 10, so if it's 5 to 10, you're talking about a 3rd-degree felony, punishable by a prison term of up to 10 years and up to a $10,000 fine. If the items obtained are 10 or more, but less than 50, you're talking about a 2nd-degree felony, punishable by up to 20 years in prison and up to a $10,000 fine. And if you're talking about 50 or more items, you're talking about literally a 1st-degree felony, punishable by up to life in prison and up to a $10,000 fine. Now, I'm going to cover one more kind of obscure element of identity theft, but it does happen on occasion. It's called false statement to obtain property or credit. So within the framework of identity theft crimes in Texas, this particular crime exists. Under Texas Penal Code, section 32.32, a person commits the crime of false statement to obtain property or credit if he intentionally or knowingly makes a materially false or misleading written statement to obtain property or credit, including mortgage loans. Okay? That's what the law says under Texas law. So here's what it's focused on. This kind of obscure law is focused primarily on criminalizing individuals making false statements. So the actual obtaining of the property or the credit is not something that is a primary requirement that the state of Texas has to prove to be charged with this crime. In fact, if a false statement to obtain property or credit proceeds to a trial, they don't have to prove anything other than you made a false statement and that it was used with the intent to obtain that credit, okay? So here's the thing. The best criminal attorneys, when representing someone on this type of offense, are looking at it, showing that the elements of criminal intent and misleading, false or misleading statements that's the area to attack. Because many times the interpretation of whether or not somebody was doing so in a false or misleading way, that can be subjective. People can kind of just draw their own conclusions, particularly detectives, if that's what they're looking into. So what is the punishment for this offense? The punishment for false statement to obtain property or credit under Texas Penal Code 32.32 can range anywhere from a Class C ticket, a Class C citation, all the way up to a 1st-degree felony. Here's how. It's based upon the value of the credit seeking to be obtained. It follows the same rules as you would theft. So if it's $500, you're talking about if the amount is under $100, it's a Class C ticket. If it's over $300,000, it's a first-degree felony. So it really depends on what it is attempting to obtain, okay? Finally, I want to say this. I'm just kind of touching these elements of identity theft. Let's say it turns out you had no intent to harm or defraud. Let's say you did not technically possess these identifying information. Let's say you did not intentionally or knowingly exercise care, custody, or control over these items. You had no idea that they were there, and they certainly were not something you were intending to possess. You need to make sure you're retaining an attorney that is going to be able to prepare evidence and make a presentation with an evidentiary packet to a grand jury. Here's why. Because the grand jury, because these are felony charges, every felony in Texas must be presented to a grand jury for indictment. These legal defenses that may exist for an identity theft case can be exposed to the grand jury, and the grand jury could potentially lower that felony charge down to a lesser misdemeanor charge, or they could possibly reject the charge altogether with a no bill. But time is of the essence. And the reason why I say that is in most jurisdictions, cases go to a grand jury within about 30 to 90 days. So the last thing you want to do is miss out on that opportunity and find out later that you could have attacked your case early in the process, okay? Now listen, these are serious charges. If you or a loved one, or if you're facing an identity theft charge, then I want to invite you, particularly if it's in the North Texas area, I want to invite you to give our office a call at the Hampton Law Firm. You see the number that's been above you, myself, the whole time. I encourage you to give this number a call. You'll reach out to one of our office staff. They can get you in touch with our office. We'll give you a free case analysis and a free consultation if you have a case in the North Texas area. And we'll be happy to break down your situation specifically and see if we can be of assistance to you. Now, I promised you if you waited around to the end of this video, I'd also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. If you'll click the link down here below in the YouTube notes section here, I'll be happy to send that right over to you. And I want to thank you for joining us here today. I hope this video was of assistance to you. If it was, subscribe to our YouTube channel, like our video, and we'll see you next time. Thanks.